Good afternoon, everyone. We will get started in just a minute and give folks a minute or so to get on. 1 o'clock meetings can be a little challenging after lunch. Okay, good afternoon. We will go ahead and get started. We are recording this session and you all should have received a notification to that. So just FYI. Okay, so welcome to Part B of our Washington Utilities and Transportation Commission UTC 101 workshop series. Hopefully many of you were able to attend Part A last week. My name is Anna Gill. My pronouns are she, her, and I am the Director of Consumer Protection and Communications here at the Commission. The purpose of these workshops is to provide education around the role, structure, and purpose of the UTC, and then dive into how organizations and the public can get involved in our proceedings. Last week, we focused on a high-level overview of the UTC, a little bit about our history and what we regulate. And today, we're going to take a deeper dive into our commission proceedings, public involvement, and our participatory funding program. Sorry, that's a little hard to say. We also have an advocate panel at the end of the workshop, or towards the end of the workshop. So before we get started, I want to go over our virtual ground rules. So please mute your microphone if you haven't already when you're not speaking. If you're on the phone, you can dial *6 to mute or unmute yourself. Don't put your phone on hold. As much as we love the hold music, we'd like to avoid that if we can. We also ask that you use the raised hand tool under the reactions if you want to ask a question. We will have a dedicated Q&A session at the end of the workshop with our staff available to answer questions related to their presentations. So if you can, please hold your questions till then. We are trying to utilize the chat only for technical assistance, although you can ask a question, and if we have time, we will address it in real time. Otherwise, we may leave it for the Q&A session. Like I mentioned earlier, we are live recording, this meeting and streaming it live. So by participating, you are consenting to being recorded. And if you speak or turn on your video to ask a question, you will be a part of that recording. And then we have a couple of other rules that we use at all of our UTC meetings, and that is to respect others. Only one person speaks at a time. And then we also ask everyone to commit to meeting each other in a positive space. Auto captions are enabled. So if you'd like to view them, you scroll down to the bottom of the controls on your screen and you will find the mute, video, chat, and reactions button. And that's where, again, you can raise your hand or select closed captions to turn on those auto captions. So with that, I am going to turn it over to Emily Brown, our Media and Communications Manager, to give you all a recap of what we covered last week. Emily, you're up.
Thanks, Anna. So as Anna mentioned, I'm Emily Brown. I'm our Media and Communications Manager. I use she, her pronouns. And I want to thank everyone for coming back this week. We wanted to do a quick recap of what we covered last week for anyone who was unable to attend. So I'll be very brief, but we can go ahead to the next slide. So just as a reminder, the Utilities and Transportation Commission, our mission is to protect the people of Washington by ensuring that investor-owned utility and transportation services are safe, available, reliable, and fairly priced. So as a reminder, that means that we sort of have two charges. One is to regulate the needs of regulated companies, but also consider the needs of our customers to make sure that those services are reliable and utilities can stay in business and earn a fair profit, but also make sure that services are fairly priced and available to our customers. So there are several divisions at the agency, and there are a few that you'll be hearing a lot more about today. We have several different utilities and transportation companies that we regulate. One of the largest bodies of work right now is probably electric and natural gas utilities. Landline telephone communications, we also regulate. We don't regulate cell service or broadband. We regulate water utilities, garbage and recycling, and then many other transportation industries such as airporters, movers, charter, buses, nonprofits. And I just really want to touch on the fact that that investor-owned word that you heard earlier is very important. We only regulate the private utilities that are owned by investors or shareholders. We don't regulate those publicly held utilities, so PUDs, public utility districts, city government like Seattle City Light or Tacoma Power. And so those are really important to keep in mind. Our companies probably offer about half of the energy service to customers in Washington state. Throughout the presentation, there will be a few different spots where we will cover some definitions, and there is a handout on our website on the participatory funding webpage, which I believe is www.utc.wa.gov/participatory funding, which we can drop in the chat if you want to take those and review them later. But just as a reminder, an RCW is the revised code of Washington. So these are really the laws of Washington state. Typically, they're passed by the Washington state legislature and signed into law by the governor. You'll hear RCW and see those references a lot today. A WAC, or a Washington Administrative Code, these are the rules that are developed by each state agency, and they tell impacted folks, companies, the community, how to implement those state laws in the RCW. So they provide more specific guidance on how to follow state laws. That was just a really quick overview of what we touched on last week. The recording is available in the docket if you want to go back and see what we covered. And as you have questions or things, feel free to reach out. But otherwise, I will hand it off to Michael Howard for the next part of the presentation.
Thanks, Emily. So my name is Michael Howard. I spoke last week as well. If you attended last week, I'm an administrative law judge at the commission. And this week I'm going to be going, it does sound like someone may need to mute themselves. So this week I'm going to be going into a bit more detail about the different types of formal proceedings before the commission. And this is basically how the commission conducts its business and some of the principles of administrative law behind that. Could we advance to the next slide? So I want to start with this quotation from Bill Gates' recent book, How to Avoid a Climate Disaster. This quote is not worded in the best way, but I still appreciate it. So it says, in the unlikely event that someone runs up to you and says, what is the most obscure agency with the most underappreciated impact on climate change? You could do worse than say, my state's Public Utility Commission. And I think this quote is certainly true in Washington state, given the passage of the Clean Energy Transformation Act and the Climate Commitment Act and other legislation. and it's a significant reason why I came to work at the commission. So I think if you are interested in clean energy issues, being engaged with the commission would be, I think, very helpful to that. Could we move to the next slide? So in my comments today, I'm going to talk about some background legal principles. For those of you who may not have a background in this area and maybe a little bit less familiar with some of these procedures. And then I'm going to talk about the different categories of formal proceedings before the commission. So that will include rulemakings, adjudicative proceedings, open meetings, and then a catch-all category for other proceedings, but I'll primarily be talking about policy statements. Could we go to the next one? Thanks. So on this slide, I just wanted to give you, for those of you who aren't as familiar with this, or maybe need a reminder about some basic principles of administrative law. And here I just wanted to give this hierarchy of authorities, that the statutes passed by the legislature are, for our intents and purposes today, controlling. They tell the commission what our authority is and set the limits of our authority. The commission can issue rules. We only get to issue rules because the legislature gives us authority to do so in statute. And our rules in the Washington Administrative Code, the WAC, are at Title 480. And the commission can also issue orders in our cases, and we can also issue policy statements. And generally those have to be consistent with both the statutory and the regulatory framework that we've already set up. The commission can grant exemptions from our own regulations, but not from statutes. And then any of our orders or our rules could be appealed to court and subject to review. Could we move to the next one? So I'll move to the first main category of proceedings before the commission. And again, I did touch on these very, very briefly last week. I'm trying to give you a little bit more detail this week. So in rulemakings, just to speak generally about rulemakings, as I mentioned, the commission gets its authority to issue rules from statute, and our rules are in WAC Title 480. One thing I really wanted to point out, though, is if you're interested in how the commission conducts its business, the procedures, how you file things before the commission, the rules of how you appear before the commission, you would want to look at WAC Chapter 480-07. And that particular chapter of the WAC is sort of like the commission's court rules, and that describes how we do our business. So that might be a chapter you may want to look at if you want to advocate before the commission. So let's say you are interested in a rulemaking, and you might have a question of how do you participate in one. So you can email the Record Center at this address here, records@utc.law.gov. You can call Record Center. Yes, and we have a question in the chat. Chapter 480-7, and that is right. It's normally written as 480-07, but same thing. Thank you. And so you can be added to the service list, so you'll be notified of new filings in that docket. You can also respond to a notice of opportunity to comment. Normally when we're conducting a rulemaking, we'll issue one or more of these notices of opportunity to comment where we're asking questions. And these questions are posed to the utilities, they're posed to stakeholders that are already participating in litigation before the commission, but also members of the public can offer comments in response to these questions. And I'll give you an example in a moment. You could also attend a rulemaking workshop. And there will be notices sent out of those in advance, and you could attend if you like, or you or your organization could attend. Could we move to the next slide? So I want to give you an example of a rulemaking that may interest you. We have a few rulemakings going on right now. For instance, there's one on minimum train crew size, but this is probably the one that most people attending this training would be interested in. And that's the Carbon and Electricity Markets Rulemaking in docket UE-210183. And this rulemaking, I'm not personally assigned to it, so I'm giving you sort of the high level overview of it. But this rulemaking has been addressing a number of complicated issues about how we evaluate compliance with the Clean Energy Transformation Act. And one of the main questions that's at issue is if one of our Washington utilities buys renewable energy from another state like California, how do we prevent the utilities from double counting and saying that the renewable energy satisfies the laws in both states? And if that was true, that would tend to water down those requirements. So in terms of how this rulemaking is proceeding, we've issued several notices for comment, posing specific questions. We've held, I think, a total of 4 workshops throughout 2021, and we proposed some rules in March 2022, and then we had the adoption hearing, and that's where the commissioners decide if they're going to agree with the rules being recommended to them. And what the commissioners decided recently was to adopt many of the rules that were recommended, but to wait and consider one issue more. So this rulemaking is still going on, and there's a statutory interpretation issue that's still being considered. So if you're interested in clean energy issues, this could be a rulemaking that you might want to keep tabs on. Could we move to the next slide? So the next main category I would be talking about today would be adjudicative proceedings. We have this slide here. The term adjudication simply means the legal process of resolving a dispute or deciding a case. And the way I would explain this to someone would be to say that we have trial-like proceedings where we don't have a jury because the commissioners appointed by the governor make the final decision in our most important cases. And as I mentioned last week, a lot of our testimony is written down and filed in advance, and our hearings are primarily for cross-examination or for clarifying questions from the commissioners. So could we move to the next slide? Okay. And then we also have another vocabulary term here, docket. If you're not as familiar with legal proceedings, the docket simply means the official record of all the filings for one particular matter. So if you go to our website and you enter one of those docket numbers, you can see everything that the commission or a party or a comment of the member of the public has filed for that particular matter. Could we move to the next slide? So just to expand on what adjudications are like before the commission, many of our most important cases, especially speaking historically, are when an investor-owned utility seeks to raise its prices to recover the costs of different investments it's made over a period of time. And by statute, we have the authority to delay their proposed price increase for up to 11 months. And so that sets up a calendar where we have to resolve the case within that 11-month time frame. And if we have rules that if a company seeks more than a 3% price increase, this is generally considered a general rate case. There are exceptions. And in a general rate case, the company has to provide more extensive evidence, especially accounting work papers and other forms of testimony that let us really closely review their investments and their books. And the commission we're still holding our hearings over Zoom. So we're still in kitten lawyer land, if you remember that news story from a couple of years ago. There are advantages to holding our hearings over Zoom. It's easier for people to attend, of course, and there isn't travel required, but of course there are occasional difficulties with reception or something like that. But we're of course not the only agency to be proceeding with online hearings during the pandemic. Can we move to the next slide? And I should also address the idea of ex parte communications. We touched on this last week, but in an adjudication, because the commission is acting in that quasi-judicial capacity where we're acting like a judge in a court, we can't talk to someone about a pending case without all the parties being present. So for instance, Chair Danner was on TV Washington recently, and he was asked some questions about a pending case, and he said, I can't talk about that because it's a pending case. So anything in an adjudication kind of falls under this umbrella of we have to be careful that we talk about this in a proper way. And this slide is expanding on that idea that, again, as I've mentioned, in our, and I'm focusing here on what is likely of most interest to you all as the audience, that in our most important cases, the administrative law judge is not making the final decision. It's the commissioners, and they're assisted by administrative law judges such as myself. And we're under the ex parte rule, so we cannot talk to one person without the other parties being present in that case. And I would say, as a comment aside, that energy regulation in general, sometimes it does amount to this kind of ongoing conversation over a period of years where parties are advancing arguments in one proceeding and seeing how those play out, and then coming back in another proceeding later or in a rulemaking. So in this environment, we all have to be careful of when something's in adjudication that we follow this rule. We can move to the next slide. So here, I want to address this question of how can someone participate in an adjudication? So basically, early in a case, once we put it in that framework where it's going to be this trial-like setting, early in the case, you or your organization would face a decision, and it's generally at the pre-hearing conference stage, which is essentially a Zoom video call with the assigned administrative law judge, setting up procedures for the case. You would have to make a decision if you want to file petition to intervene and seek party status, or if you don't want to do that, you don't want to seek party status. So if you are granted party status, there are definitely advantages to that. On the left side of the screen, they're listed here. You can present more extensive testimony and argument. You can present witnesses. You can formally obtain information from the other parties, including the utility, through discovery requests, where you're asking them for information. They have to provide information to you, subject to certain exceptions. Some of the drawbacks are the time, the staff time of your own organization, your own time, the cost of hiring expert witnesses, the costs of hiring any attorneys you may need. And there's also a question of whether your particular petition would qualify for the standards for intervention. It's in the commission's discretion whether to grant that. So that would be an issue for you to consider carefully. If you don't have that party status and you're not actually a party to the litigation, you can still participate in the case. And that's a very important point I want to emphasize. And there are advantages to that. It's much lower cost for the organization, for the advocacy organization. There isn't the need to present this extensive testimony and to necessarily hire an attorney. Your comments are considered, and I'm going to talk about that more in a couple of minutes. And some of the drawbacks, though, are it is a much more limited role, and there's more limited feedback on how exactly your comments were considered in the final decision. Normally, our orders will summarize the comments. We might talk about some of the most pertinent public comments, but we're not necessarily going to weigh and discuss each of them. Could we move to the next slide? So I want to give you some examples of pending adjudications right now, and I'm just kind of advancing my notes here on the side. So some pending adjudications going on right now. We have Puget Sound Energy's general rate case and its first multi-year rate plan under some new legislation. And I have the docket number there, consolidated dockets UE-220066. And we have Puget Sound Energy's first clean energy implementation plan under the Clean Energy Transformation Act. I'm trying to say all this without using acronyms. And that's in docket UE-210795. The clean energy implementation plans are very significant because they're the utility's 4-year plans for meeting these clean energy goals. I'm not going to talk about either of these cases specifically because I am the assigned ALJ and they are in adjudication. So that ex parte rule comes into effect Yet again, this is an example of that. And then to give you one more example of an adjudication that might interest you is Avista's general rate case and first multi-year rate plan under the new statute, which is in UE-220053. Could we move to the next slide? So I want to take a moment kind of as an aside and talk about the idea of public involvement and some of the background rules that play into that. So as a general matter, I'm going to try and keep this very short and simple. Yeah, you could think of every price or service term or fee that the utility charges you as a customer. If it's one that we regulate, it's in something called their tariff, and their tariff is on file with the commission, and we have to approve it. It's like a contract between you and the utility, but the commission's approving any changes to that contract. So every time the company wants to change some portion of their tariff, they have to send a notice to their customers, and that's generally 30 days in advance. And those notices provide information on how you can respond to them as a member of the public. The commission also has staff that reviews these notices and responds to customer questions about them. So here we're talking about general questions in response to notice from your utility company, maybe when you don't necessarily have a docket number in mind, you're responding to a notice. Could we move to the next slide? So if you wanted to just submit a general public comment and you don't necessarily have a particular docket in mind or that you're aware of, you can use our online comment form through our website. You can email comments at utc.wa.gov, or you could call or write us at these at this phone number and address here. And we can certainly provide that later on if that was too fast for you to read. I'm just going to move on in the sake of time. And I want to expand on the idea of how we consider comments. Generally, the commission staff or public counsel will prepare a summary of all the public comments, who's in favor of a price increase, who's against it, who's neutral, and what are their specific points that they're making in the comments. And that goes into the record. And they are considered, as I mentioned, they are considered in the decision. We summarize them, and we'll discuss particularly salient comments. And they do factor into the decision. Could we advance to the next slide? So I want to talk next about open meetings. And this is the next main category of proceedings before the commission. Can we move to the next slide? So open meetings, you might, if you're not familiar with the ins and outs of Washington state government, you might wonder why we're using the term open meetings. And that's because there's something called the Open Public Meetings Act that requires agencies like ours to conduct most of our business in a public setting. So it keeps government from holding secret meetings and making decisions away from the public eye, basically, because we like accountable open government in Washington state. And the commission's open meetings are generally every other Thursday at 9:30 a.m. The exact schedule is on our website. And normally the agenda for any particular open meeting is going to be finalized the week beforehand. So if you are interested in energy regulation in our state, you might want to keep apprised of what we're doing on the open meeting dockets. Can we move to the next slide? So I want to give you an example of a recent open meeting that we had that's already done, and how we might look at the agenda to see what items might be of interest to us. Generally, we have, at a normal open meeting, we have the discussion agenda, which are items that the commissioners are going to debate and discuss. And then we have the consent and no action agendas, which are items that are generally routine, and they're just going to be approved likely by the commissioners, but we don't anticipate much discussion on them. So is it possible to open the link at the top of that slide? I apologize, I'm going to dismiss this call. Great, thank you. So this is an example of an open meeting agenda from June. And I just wanted to show you this briefly so you can see, if you're not familiar with how we do our business on a regular basis, you can go through one of these and you can see if there are items of interest to your organization. So here we have the A agenda item on the first page, A for utilities. This is the discussion agenda. The commissioners plan on going through these one by one and discussing each of them. And for instance, number one is a purchase gas cost adjustment from Avista, where Vista's coming in and simply saying, the price of gas we're buying on the market has gone up and we need to recover the cost of that. So if you are interested in one of these items, you could appear at the open meeting and ask to briefly give some comments. And generally you'll be allowed a few minutes to give comments on one of these items. And if we could scroll down, we have more filings in the utility docket. And if we could keep scrolling down, we have the B items for transportation. Generally, those are significant, but they're probably not the focus of our training today because those are generally solid waste cases in other industries. And then towards the bottom here, we begin to have the consent agenda and the no action agenda. And here we can have filings by utilities that are generally considered routine and not very controversial, that will probably be approved without much discussion. But if one of these does jump out to your organization as something that you are interested in, you could appear at the open meeting and ask the commissioners to move this to the discussion agenda and ask for time to give comments and to discuss this. All right, could we go back to the PowerPoint and move to the next slide? Thank you. And so here I just want to briefly touch on other types of proceedings. We have a number of other types of proceedings like investigations, dig law, penalty assessments, and a number of things. But I want to really focus today on policy statements because I believe that would be the most of interest to who's attending this training. So the commission will provide non-binding guidance in policy statements. And there's a number of relevant policy statements to energy regulation and to the regulation of the investor-owned utilities. So I want to give you two good examples of recent ones. Here at the top of the slide here, we have docket U-210590, which it's still in progress, and we're preparing a policy statement on performance-based regulation. There was a statute passed recently that kind of expands on the concepts of performance-based regulation in our state and sets forth new requirements for performance-based regulation. And so that docket raises a number of complicated issues around the regulation of utilities. So if you are interested in where regulation is going to go in Washington State over the next several years, you may want to stay apprised of that docket. And then my second example here is docket U-210595, which is where we issued our policy statement on participatory funding, which we've talked about. And that's this recent legislation giving us the ability to help defray the costs for advocacy organizations coming and appearing before the commission. That's a very recent thing. And it's likely that this program is going to evolve some over the coming years, and it would likely occur in that docket, I imagine. Could we move to the next slide? So a takeaway here about policy statements is that they might not be binding, but they generally reflect the commissioner's expectations of how they want cases to proceed. And that's certainly true if it's the same commissioners who sign the policy statement and it's recent and that are deciding the case before them that particular day. So advocates can use policy statements to make their arguments much more persuasive, and companies should also pay close attention to policy statements as shown by this quotation here from a recent final order. Can we move to the next slide? So that's the end of my comments today. I'm happy to answer any questions at the end of our training. I hope that gave you kind of an overview of how we conduct our formal business. And if you have suggestions for how I could improve this the next time around, I'd appreciate it. Thank you.
All right. Good afternoon, everyone. My name is Kate Griffith. If you were at our training last week, you might remember me. I'm an energy policy advisor with the Commission, and my discussion today is going to go over this new program that's been mentioned now a couple of times called participatory funding. So now that you've had more information about the types of proceedings at the Commission and a little bit more about how to participate, we're going to move into how to access money for participating in Commission proceedings. And again, it's a very new program and it's known as participatory funding. So let's stay on this slide. I want to first give you a bit of background. As you may have inferred from Mike's presentation just now about all the different types of proceedings we have going on, the work of participating in Commission proceedings can be very costly and it can be long. Proceedings such as rate cases, those adjudications, rulemaking, certainly policy statements, those can all stretch on for months. And there are multiple points in the timeline where participants read and respond to technical documents and proposals. They might interpret law, such as the meaning of an RCW. On one of Mike's previous slides, he mentioned that the word use or use is an argument in one of our proceedings. That's not uncommon to have arguments around the meanings of single words. And advocates might also advocate for their positions a couple of times, multiple times in front of the Commission. Historically, only a few organizations have had or have taken the opportunity to participate in Commission proceedings and help shape the direction of regulation in Washington State. That's likely largely due to the barriers that folks face in this space, which we'll get into a little bit more. Increasingly though, and if we could go to the next slide, there are new laws like the Clean Energy Transformation Act and others, which we mentioned in our training workshop last week, so you can take a look at that recording. We're not going to go into a ton of detail with them today, unless you have questions at the end of our presentation. But these new laws center equity in the clean energy transition, and customers and advocate groups are increasingly interested in learning how to navigate the conversations taking place in utility regulation. For the purposes of today, we are going to be specifically talking about energy utility regulation. Participatory funding is really only available for the energy spaces at the Commission. So as interest in utility regulation has grown, lawmakers in Washington increasingly heard of barriers interested individuals and organizations have faced in accessing Commission processes to advocate for their positions. And these barriers include, but are definitely not limited to, the length of the processes. Again, a rate case alone takes 11 months. We have processes that can last for years. Barriers also include technical knowledge and jargon needed to participate. Mike alluded to acronyms. We use a lot of acronyms, although we're all trying very hard to stop doing that. And costs of participating, such as hiring lawyers to help navigate a proceeding, especially if it's adjudicated, or hiring staff to dedicate time to an issue that you're interested in advocating for. And then again, there are certainly more of them. That's just a few. So if we could go to the next slide. To assist with one of those barriers, which is the cost barrier, the state legislature passed Washington statute RCW 80-28-430. You can Google that and find the statute during the 2021 legislative session. This law provides statutory authority for the regulated energy utilities, those are Avista, PSE, Pacific Power, Northwest Natural, and Cascade Natural Gas, to provide financial assistance to organizations. And that term organization is key. We'll get into it a little bit later. But to provide financial assistance to organizations looking to participate in the Commission's regulatory processes. So a couple of things about this law: it allows for ratepayer dollars provided through utilities to assist energy utility customer advocates in representing their positions before the Commission. So ultimately, this is ratepayer funded. That's part of the reason why the Commission, as you'll see later, is very careful about how and when it will award funding. But in addition to providing the statutory authority for funding agreements, the law requires the Commission to approve, reject, or modify the agreements and set some standards for how the administration of this program works. So the Commission has broad authority over how this program is run. And as Mike alluded to, it may be changing some of these processes in the future, but we're going to talk about how it works today. The law also prioritizes certain organizations representing vulnerable populations and highly impacted communities to receive funding. So if we could go to the next slide. Highly impacted communities and vulnerable populations are two important terms that are defined by another law that we've mentioned before, the Clean Energy Transformation Act. The RCW for that law, which you can also Google, is 19-405-020. But vulnerable populations are communities that experience a disproportionate cumulative risk from environmental burdens. So communities who are experiencing risk disproportionately from burdens that include adverse socioeconomic factors. That could include unemployment, high housing and transportation costs, access to food and healthcare, and linguistic isolation, so language challenges, and also what the law calls sensitivity factors. So these could be low birth weight or higher rates of hospitalization. The second term that's important to know for the equity provisions of participatory funding are highly impacted community, a community designated by the Department of Health. It's based on a cumulative impact analysis, which is also required by the Clean Energy Transformation Act, or a community that's located in a census tract that is fully or partially on Indian country as defined by federal law. So highly impacted community is a little bit more straightforward to identify. It's literally mapped, it's geographic. So those maps are provided by the Department of Health. If you're interested in that, we can provide links later. I don't have one handy to drop into the chat right now, but definitely let us know. Or again, a tribe identified by federal law. So these definitions are important for the equity provisions, which I think I'm going to start covering in the next slide. So if we could move on. These next two slides are going to talk about how the commission is implementing that RCW. So as Mike alluded to or had a slide about, it all kind of flows from statutory law, which is the RCW, which I just explained, to how the commission is going to interpret that law and implement it. So we did that through a policy statement, one of those types of proceedings that Mike addressed. Last fall, the commission published a policy statement to provide high-level guidance in implementing the first funding agreements in Washington State. In that, sorry, I see questions, but I'm going to get through this and then I'll go back to them if my colleagues can help answer those in the chat, if that's okay with you. But in the policy statement, the commission outlined several expectations that it had for this new law and its implementation. This includes caps on the total amount of funding it would authorize for the year. Again, these are ratepayer dollars, so the commission is careful with how that money is going to be spent. The policy statement also included initial discussion on how it would prioritize those equity communities, the highly impacted communities, and the vulnerable populations for funding. And one key aspect of that prioritization, which you'll see on this slide, is that at least 1/3 of all funding amounts must be reserved for organizations representing those groups. So within the caps, at least 1/3 of that money is reserved specifically for organizations representing highly impacted communities and vulnerable populations. The commission also stated its intention to continue conducting outreach and engaging with organizations representing highly impacted communities and vulnerable populations for both the development of the policy guidance and for future iterations of the program. So again, this may evolve as we gain more experience with it. This is the first time the commission has ever had anything like participatory funding. And for the second piece on the slide, or the continued outreach, I'm sorry, go back one slide. For the second piece around continued outreach and engagement, we're also looking at the day-to-day elements of access to participating in our processes, such as providing time and expertise to organizations that are new, providing one-on-one workshops like this and more. We of course welcome your ideas for other learning opportunities we can provide, and there will be a survey later if you want to help us, learn more about what you'd like to know. So now we can go to the next slide, and I think this is my last bit of background before we get into actually applying for these funds. So next sort of stage of guidance from the RCW to the policy statement to an actual proceeding that took place in an open meeting, we have an interim agreement. So the statute revolved around this concept called an agreement, which the commission approved in February of 2022 with modifications. So this agreement was negotiated between interested organizations. This was largely the folks who have participated in our processes before, as well as the utilities. And this first agreement, for the most part, is modeled on similar funding opportunities in the Oregon Public Service Commission. So if your organization advocates in other states, not just Washington, it's possible that there are opportunities for this there as well. You might want to ask that Public Service Commission. And while it was largely modeled on what was happening in Oregon, there are some changes to better fit with Washington's law and the Commission's policy statement. So this agreement is important for you if you're interested in accessing funding to know about. It guides the procedural elements of funding with a lot more detail. So that means that it's got information about when parties should seek funding, filing timelines, budgets, discussions of allowable expenses, and so on. And what's important to know too is that folks who are not part of those negotiations for the initial agreement, you can still participate by signing a signature page and submitting it to the commission. And you'll want to do it in the docket, as Mike mentioned, for all of this participatory funding stuff, which is U210595. So again, what's key for you to know here is the kind of stacking of law and guidance and processes that have created this program and where you can find details on how it works. So if you look up that docket attached to this program, which is again U210595, you'll find all this information, including the agreement, which is a living document for how this works, and the policy statement that might help you better understand what the commission is looking for when it approves agreements. And you can also ask the UTC questions about the program. I'll have a slide with contact information later this afternoon. So if you want to access participatory funding for your organization, you need to submit a signature page to that agreement in docket U210595. That makes sure you're part of the agreement that will enable you to access all the funding. So next slide will help us get into this a little bit more. Who is eligible and what costs are eligible? And before I dive into this slide, remember that this is for energy utilities and largely energy proceedings. It's not really relevant to water or telecom work, for example. So if you look on the left-hand side of this slide, the commission scoped eligibility to receive funding to nonprofit organizations, and it also disallowed government agencies from accessing funding, with the exception of tribal governments. As you'll remember from those definitions I showed you earlier, tribes are considered highly impacted communities. So if you are a for-profit company, or for example, if you are the city of Seattle, you are not eligible to receive participatory funding. The statute also requires that organizations receiving funding must represent broad customer interests, including low-income customer interests, commercial and industrial customer interests, or the interests of vulnerable populations or highly impacted communities. Over on the right-hand side of the slide, the Commission's policy statement also scopes the expenses that are eligible for funding, at least in this first year of the program. As part of the prioritization of highly impacted communities and vulnerable populations, these expenses may be different from group to group. And again, these are equity components of the law. So I hope that this is legible to you all. And oh, I guess it's just small for me, sorry about that. But the example costs are listed in the first column. For all customer advocate groups that are not groups serving prioritized organizations, only consulting fees, direct fees for participating in a proceeding, such as consulting fees or legal fees, are eligible expenses. For groups serving prioritized organizations, those expenses are eligible, as well as more expenses related to training or technical assistance or outreach to help enable groups that have not been historically involved in our processes to have better access and understanding to those processes. So how do you apply? And we can go to the next slide. I mentioned earlier that your organization does need to sign a signature page first, but after that, organizations seeking funding in the proceedings or cases they want to participate in, it follows these steps. So the first step is to know the docket number of the proceeding for which you're seeking funding. If you're not sure of a docket number or docket numbers that might interest you, you can reach out to the commission. And again, I've got a slide with contact information coming up. Knowing the docket number is important, first, because of what Mike outlined, because everything about that proceeding is going to be listed and provided under a docket number. But also for purposes of funding, you'll have to follow the procedural elements of the docket you're interested in. So if you're participating in a rate case, you'll have to follow the schedule the judges lay out for that adjudication. And all of those timelines and all of that schedule will be announced and explained using notices posted to the docket. Okay, so you know the docket number, you understand how to navigate a website and information lists for the docket, you submitted a signature page already. The next step and the real step for starting to request funding is to create and submit something called a notice of intent to seek funding and request for case certification. This is a very long named thing that is essentially a notice that alerts the commission that your organization is interested in seeking funds, and it is one threshold step to accessing funding. So the commission and its administrative law judges will approve or deny your eligibility as an organization to seek funding based on this notice. It's the step that kind of determines, is your organization or is this proceeding even eligible for funding? And that's what the little gavels are between these steps. The commission must approve or reject with or without conditions each of these steps that are marked with that gavel along the way. So once your organization is acknowledged as an approved organization, you'll work to submit a budget proposal. This budget proposal should outline why you seek funds, the amount you seek, the reasons why the commission should grant you this funding. And the commission and its administrative law judges, again, will consider your organization's proposal seeking funding and issue a decision, again, either approving with conditions, modifying, or potentially fully denying the budget proposal. After all of that, you'll basically go through your business in participating in a proceeding, as Mike explained earlier. And finally, when you've been approved to receive funding, the money will be released to you at the conclusion of a proceeding, or if you're an organization representing a vulnerable population or highly impacted community, money can be released to you during the middle of a proceeding after you file a request for payment. So that's this final step. Along with the request for payment, your organization needs to file receipts and invoices showing your use of the funds and a detailed narrative that explains the use of the funds, how they met the terms of your fund grant, if the commission had placed any conditions on that. And after reviewing this request, the commission will issue an order that directs the utility or utilities that were engaged in this proceeding to provide you with that payment. In very extraordinary circumstances, it's possible that if the commission finds there's been a misuse of ratepayer dollars, the commission may reject the request for payment in entirety. But again, these are the three kind of steps along the way. Each time you need to gain basically commission approval to proceed forward. So this is a lot of info on process. And as I've mentioned a few times, the commission is here to help folks if you need help navigating the process and issues. So I think let's turn to the next slide for that. If you have any procedural questions, your best point of contact would be our administrative law division. And so you can email them at ald@utc.wa.gov. You can call at 360-664-1234. That's an easy phone number to remember. Or you can go to our website where we have a lot of detail and contacts, as well as links to the laws and the policy statement. So that's utc.wa.gov/participatory funding. Next slide, I think. So I had mentioned that in the policy statement, the commission had outlined certain caps on funding. This is how much it's willing to consider for the first year of funding for 2022. And these caps may change in the future, but for now they're set. So this slide shows you the total caps for each energy company we regulate, how much of that cap has been budgeted or allotted for the year. No payments have been made yet. This is still a very new program, and how much of the funds are left in that cap unallotted for each utility. So for PSE, the cap was $300,000. Of that, all $300,000 has been budgeted. So for 2022, there is a zero amount left for budgeting for PSE related proceedings. For Avista, another $300,000 was budgeted. $300,000 was allowed under the cap. 170 of that has been budgeted, and so there's $130,000 left. Pacific Power or Pacific Core had a $300,000 cap. None of it has been allocated or budgeted, and so there is the full amount left. For Cascade, 265,512 was allowed under the budget, and a little over 75,000 has been allocated. So there's a bit over 190,000 left. And finally, for Northwest Natural, which is one of our smaller footprints of utilities in the state, just under $73,000 was allowed under the cap. Nothing has been budgeted, and so the full amount is left. I think we can go to the next slide. So as mentioned, the interim agreement broadly guides the process of applying for these funding dollars and uses a rate case. I wanted to mention this, that it uses a rate case as kind of the model for those timelines, but funding dollars are available for other proceedings that are not rate cases. So I wanted to provide a couple of dockets that might be of interest to folks and that may be eligible for funding as well. The first one, I think we mentioned most of these in our workshop last week, so I'm not going to go into a ton of detail here, but the customer notice and disconnection fees rulemaking may be of interest. That's docket 210800. Clean energy implementation plans might be of interest. Those are ongoing for PSC and PacifiCorp, although as I mentioned, PSC's cap has been fully allotted, so it may not be possible to request funding in that docket. We also have the gas decarbonization study, as well as something called performance-based regulation, which Mike alluded to earlier, and we have the rate cases. So I'm not going to list all of these dockets verbally. That would be a lot of numbers to go through, but if you have any questions about any of these, the slides will be available, but we can also send you links to any of those dockets that you might be interested in as well. And next slide, please. Okay, sorry, that was the end of my presentation. I know there were some questions in chat, so I will take a look at those unless Emily or Kristen, is there anything you think I should answer verbally now?
I just think it might be useful to answer the question that was asked in the chat, which was essentially, do the utilities have discretion on who they choose to give funding to, might introduce bias? And if you want to just talk about that for anyone who watches the recording later and can't see the chat.
Yeah, that's a great question. The utilities do not have discretion on who they choose to give funding to. So that was a big topic of conversation when we were in the policy statement proceeding about making sure that it was the commission that had full authority over this program. So the commission is the one that makes the decision about who has access to the funding, not the utilities. Does that help answer your question, Olivia, or is there anything additional that I can answer there? Okay, great. All right, I will answer the rest of these in the chat and I think we can move on.
Okay, thank you, Kate. So really quickly, we wanted to do a promotion of some of our pair work, and that's pro-equity, anti-racism. So next slide. So as you may or may not know, the UTC is working closely with the Washington State Office of Equity to transform state government to promote access to equitable opportunities and resources that reduce disparities and improve outcomes statewide across government to ensure that everyone in Washington has full access to opportunities, power, and resources that they need to flourish and achieve their full potential. So this work is taking shape as a pro-equity, anti-racism ecosystem where the community really is our guide. And so the UTC's pair work is our pair team is working to break down our business lines and incorporate pair values and develop relational partnerships with the community and external partners. And so as part of that effort, next week, we are holding a pair virtual listening session to hear from the public and our external partners to help us identify barriers to accessing commission services and also participating in commission proceedings. So the listening session is scheduled for 2 p.m. next Thursday, July 28th. We should have a link going into the chat to that Zoom meeting, but we will also have the link available on the events calendar on our website, as well as up in the carousel on the homepage of our website by early next week. If you can't participate in next week's listening session, we do have an active survey that has all of the questions that we will be discussing during that session. And so you can fill out that survey if you can't make the meeting and want to make sure that your feedback is provided. So we hope to see you there, or at least hear from you. So with that, we will go ahead and take a 5-minute break. It's 2 o'clock on the nose. So if you can be back at 2:05, we will start our advocate panel discussion.
Yes, and while we're on the break, I just want to ask our advocates to stay. We're going to use this time to make sure that we don't have any technical difficulties and continue so that folks can make sure that they see you while we have this conversation. Okay, I see Tyler. Hello, Tyler.
Kate, how are you?
Marielle is here as well. Hi,
Doing
Tyler.
well. Oh, hi, Marielle. Hi, Amy. Kristen, if you're there, are you able to pin, or do I have, oh wait, I have access to pin. Okay. I'm going to start pinning you all.
Is it giving you the option to spotlight, not pin?
You'd rather I spotlight and not pin?
Yeah, because if you pin, I think it just is for you.
Oh, you're right. And I don't have the opportunity to spotlight. So if you're able to spotlight Marielle, Amy, and Tyler, that would be great.
There we go.
Not sure what I'm not sure what spotlighting is. Could you tell me how to do it?
I think that Kristen can do it for us,
Okay.
Marielle. So it will, I hope your voice is okay. Thank you for joining us.
Thanks for reminding me when we spoke earlier this week.
No worries. Okay, so we've got you all pinned or spotlighted, and that just means that folks will be able to see your faces as we're having this conversation. And I think since we're on break for the next 3 minutes, if you all want to turn off your own cameras and take a quick break, we'll just get started right at 2:05.
Sounds good.
Thank you. All right, so it is 2:05. We're returning from a short break and moving into an advocate panel discussion. We thought it might be helpful for folks that are interested in participating in commission proceedings to hear directly from advocates who have participated in proceedings for years, as well as participants who started participating, that's a lot of participating, in commission proceedings over the last 2 or 3 years. So I'm going to do a quick introduction of our panel speakers. And then Kristen, we could probably just stop sharing the PowerPoint once we get into the discussion, but I want to keep it up as we're doing intros. So one of our first panelists is Marielle, who represents an organization called Front and Centered. Marielle is an environmental law and policy specialist leading Front and Centered's commitment to advancing the clean energy interests of frontline communities in Washington that are historically disproportionately harmed by climate change. And I'm going to ask each of our panelists to maybe do a couple of intro remarks themselves to add a little bit more that I'm not going to get to in my brief introductions of you as well. Our next panelist is Amy, who is here with an organization called Northwest Energy Coalition. Amy works at the Northwest Energy Coalition, a nonprofit alliance of around 100 environmental, civic, and human service organizations, progressive utilities, and businesses in Oregon, Washington, Idaho, Montana, and British Columbia. The coalition advances for clean and affordable energy, promoting development of renewable energy and access to energy conservation, consumer protection policies, low-income energy assistance, and fish and wildlife restoration. And next, last but definitely not least, we have Tyler, who's here representing the Association of Western Energy Consumers. Tyler is actually an attorney with Davison Van Cleve, which represents this organization, an industrial organization that we often see at UTC proceedings, the Alliance of Western Energy Consumers. In his energy work, Tyler has represented clients before state utility commissions in all manner of proceedings, including rate cases and complex legal and policy dockets involving issues such as customer choice, integrated resource planning, and renewable portfolio standards compliance. So with that, I'm just gonna pass it to each of you one by one. We'll start with Marielle, if you have any intro remarks you wanna make about you or your organization or how you've been participating in the commission broadly.
Hello, everyone. I'm so glad everyone could make it and that there has been such high interest in this topic. I have been participating in commission proceedings for a couple of years now. After CETA was passed, but as the rulemaking was taking off, I joined Front and Centered, and my role with Front and Centered was largely to track the rulemaking and follow opportunities to speak up for the organization and for us to kind of remain involved, because Front and Centered had been active in the legislation being drafted and passing the Clean Energy Transformation Act. I learned that there is so much more. There was a lot going on with CETA, but there's so much more than CETA with the commission. And although I had some of the basic resources about how the commission functions and the history, it was pretty overwhelming initially, and it remains a lot of ground to continue exploring and learning about even after a few years. So I'm grateful that Front and Centered has been able to remain active in CETA and related dockets, and with respect to some other issues that are dealt with by the commission. It's just enormously important. It doesn't get a lot of attention or a lot of participation by diverse organizations representing the interests of communities who are very much impacted by utility operations and by large-scale decisions around resources and all sorts of activities about scaling up and building out and transitioning everything around how the system works. So I have learned a lot about how the regulatory side is so critical to the energy system at large, and the impacts on people's lives and well-being by just always exploring that connection between the formal proceedings and what are the outcomes? What are the outcomes, not just of, oh, there's an order, and that order gives a direction to utility. The utility takes an action on the basis of that direction. And then what? What does that action mean? Just making sure that the human, the human outcome is really seen and felt and elevated in attention during all that process. So please reach out if you have any questions more about my learning and front and center of the organization that I work with. But maybe I'll speak to that in response to some of the questions that come up. Thanks.
Yeah, thank you, Marielle. Amy, do you want to give a quick intro of yourself and your organization that I didn't already touch on?
Sure. Thanks, Kate, and thanks for having me today. I'm Amy Wheelis. I'm with the Northwest Energy Coalition, which is a public interest organization working on energy policy and clean energy issues across the Northwest. I've been at the coalition for about 5 years, and before that, I didn't really have any utility commission experience. I also don't have a law background, I think, which is slightly different from my two co-panelists here. We frequently participate in proceedings before the UTC on clean energy issues, as well as some related issues on consumer protection for customers. We also work pretty frequently at other utility commissions in the other states we work in, Oregon, Idaho, and Montana. So we have kind of can see some best practices at the different commissions that we sometimes encourage other commissions to adopt. So I'll leave it there and maybe turn it over to Tyler.
Yeah, thank you, Amy. Tyler, please let us know more about you.
Sure, thanks. I'm Tyler Peppel. I've been an energy attorney my entire career. I joined Davis and Van Cleve in 2013, and I've been representing as one of my clients the Alliance of Western Energy Consumers, both at the Washington UTC and at the Oregon Public Utility Commission. And AWEC, the Alliance of Western Energy Consumers, is they're a nonprofit organization that represents industrial customers, so the largest energy users on the system. And so they have sort of a specialized interest in the cost and reliability of the system. And so we typically intervene in adjudicated proceedings is where we spend most of our time. Probably get into that a little more detail as we go forward. But our primary focus is to try to look at the utility costs and try to keep them as low as possible. And that's not only sort of inured to the benefit of industrial customers in Washington State, but really to all customers in the state. So I think that the organization plays a pretty important role in the process. So I'm happy to keep talking about that and answer questions as we go along.
Thanks, Tyler. And for anyone in the audience who has questions for our panelists, if you want to raise your hand or type them in a chat, I'm going to go through some of the questions that I want to ask them to make sure that they can provide information to you. But if you have anything additional, just please let us know by either raising your hand or typing them in the chat. So the first question is to all of you, and I'll maybe kick it off to Amy first. But for organizations who might be interested in advocating before the commission, can you describe how NWEC, or for Marielle and Tyler, how Front and Centered, or Davis and Van Cleve, or AWEC, make the decision to participate in the docket, whether it's an adjudication or a non-adjudicated proceeding, like a policy statement or a rulemaking? And like, what types of internal organizational considerations or advocacy and issues considerations do you make when you're making those decisions?
Sure. So we're a fairly lean organization. We have 3 policy staff here in Washington, as well as our policy director. And so we can't do all the things we want to do, as any nonprofit finds themselves struggling with. So we do keep our eyes on what's going on, and we prioritize rulemakings and petitions and policy dockets that are directly related to the clean energy space, particularly around energy efficiency, which is sort of one of our core pillars of our mission. So for a big proceeding like a rate case, we have to decide whether there are big enough issues at stake for our mission. that can justify the staff time and the legal costs that it might cost us. We don't currently have a lawyer on staff or on retainer, so we also have to communicate with some of our regular legal counsel about their availability, their interest, whether they have any conflicts of interest. I'll just note, it is possible to formally intervene in an adjudication without a lawyer at the UTC, which isn't the case for all utility commissions across the country, but it is often very helpful. So for less formal proceedings, we often talk with other organizations that might be similarly aligned on the particular issue to talk about, like, are they going to participate? Would it be beneficial for us to collaborate on comments? Are they going to have a different perspective than us, which is fine. And then that helps us figure out, like, how much of our staff time are we going to dedicate in a particular area.
Awesome, thank you. Marielle, do you have any thoughts on that? How front and centered makes those decisions?
I can't, and thank you for your comments, Amy. I was thinking what I could say differently than what Amy shared. We have this very similar process, just assessing how close our interests align with what's at stake in the proceeding, and what our capacity is to take it on. And there's definitely an element of interest, almost everything that could happen at the commission. But we have predetermined priorities that we set out in our own work planning and in internal strategic planning. We also have an interest, so we have an interest in some concrete goals and outcomes from specific proceedings and what they're supposed to lead to. We definitely have an interest in just being present, not even necessarily as front and centered, but as an organization that is concerned with the outcomes for communities and concerned with thinking about benefits beyond the more usually defined cost and reliability, like Tyler referred to, but thinking even broader about benefits and impacts. And there's a lot of what could be that we lean into, even if our ultimate goals and our ultimate vision around a just transition towards a more regenerative and equitable system overall, there are so many steps to get there, and there's no one proceeding or one outcome from any current proceedings that will make us feel like, oh, we have accomplished this, we are victorious. It's all pieces of a larger puzzle. So just thinking how big a piece that could be, and what are the relationships that we're building on the way, on the journey of moving towards achieving our vision. And those relationships include with commission staff, with the institutions, the involved institutions, with other stakeholders, and just a lot of the commitment to what is the learning that can happen by participating in these types of proceedings, formal and informal. And that learning can be applied to our kind of big picture planning and strategizing. And ultimately, how can we bring more folks, more perspectives, greater representation from diverse impacted communities into this space, so that it does not feel like front and centered has to show up because we're the only ones who can, because we're the only ones who know about it, who have the resources, or because we represent all communities of color, and not really wanting to represent interests that aren't present, but very much interested in having more presence in these important proceedings. That's part of our calculus.
Yeah, thank you for that, Marielle. Tyler, is there anything new that you would want to add to sort of those internal considerations that you, Davis and Van Cleve or AWEC make? And maybe if you might expand a little bit more on how you make decisions to resource adjudications like rate cases versus a rulemaking or some other non-adjudicated docket, if there is a difference in terms of staff time or staffing or that kind of thing.
Yeah, well, there's some similarities and some differences, I think. I think for us, it sort of fundamentally comes down to kind of a cost benefit analysis, which maybe is a sort of similar and sort of different to what Mariel and Amy were saying. But I think that we sort of look at where are the cases where kind of the most money is at stake, and we try to prioritize those cases because those are the ones that are going to have the greatest impact on customer rates. And so, AWEC has a budget just like any other nonprofit, so we can't be everywhere all the time. So we definitely have to prioritize certain cases over others. One thing about an adjudication versus other proceedings at the UTC, adjudications can sometimes seem kind of scary, and that there's kind of like a high bar for participation because there's a lot of process and it's kind of formalized and that kind of thing. But a benefit of it is that usually it is time limited by statute, and so there's going to be like a lot of process for 8 or 9 months, but that it's only going to be 8 or 9 months when you have to do that process. Whereas if you have a rulemaking or you have an investigation or you have some of these other processes, they can go on for years sometimes. And the amount of investment that requires, you really have to kind of know what you're getting into on the front end, and sometimes it's not always clear. I think that we typically try, I would say that we have in the past prioritized adjudicative proceedings over non-adjudicative ones, primarily because that's where really the costs get decided for the most part. But there's like the rulemakings for CETA, for instance, we've been involved in those because they're going to eventually influence what investments the utility makes and how they make those investments, and ultimately that's going to result in what the costs are to customers. So I think Mariel has maybe a more amorphous goal than I do, which is some good and some bad. Mine sometimes I feel like, well, did I save my client more money than I cost them? If I did, then great. So it's we definitely are looking at some of the broader, bigger policy issues as well. But it's kind of a mixture of that and just sort of the hard numbers. So.
Thanks, Tyler. And I want to go back, Mariel, to you for a minute, and then we'll touch back to Amy and Tyler. But you had mentioned one piece of a bigger puzzle. And I think that gets into one of the questions I had for you all, which is, how do you plan or navigate long-term for your advocacy at the commission? So if your arguments don't pan out in one proceeding, such as a rate case, do you pick them up again in another, like a rulemaking, or how do you make those kind of long-term decisions? And I guess this is also kind of getting at what makes you keep coming back.
For us, we're front and centered, and for how I've brought my advocacy into the space, it is about not really arguing for the proceeding, or even definitely keeping in mind wanting to see certain outcomes and wanting to have a certain influence on the decision makers on the decision, and needing to kind of be strategic about that. But ultimately, a lot of arguments, they exist beyond what this commission proceeding is, and so it's about kind of restructuring and framing them to fit into kind of the proceeding appropriately, to kind of make sense and speak to what's at stake, but understanding that kind of that bigger picture is what guides us. And so there's definitely value in, and then one reason that we come back, and we'll continue to come back, or we'll find ways to hopefully to continue to support, like I mentioned before, kind of building and strengthening a foundation of understanding and appreciation around equity principles and values related to the just transition, and more expansive thinking about the responsibility and accountability of existing energy system players towards social welfare, well-being of communities, and towards investing in how the system needs to be transformed to respond to the urgency around the climate crisis, and kind of strengthen our social fabric. So we have big goals in mind, and it's just about figuring out what are the inputs now that can plant the seeds and water the seeds and make sure that language and vocabulary around kind of these important principles, and then kind of working towards those ultimate goals, that they are heard enough times, that they're repeated, and that they really sink in, and are disruptive to what is the or what historically has been the more standard way of wonkiness and reverting to more technical language and pretty structured and rigid thinking around the limitations of authority over utility entities, and just also the limitations of the oversimplification of how the system works, and just agreeing that it works this way and we have to just continue to make sure it works this way. And we're about thinking like, how else could it work? So just showing up to at least make sure that this disruption is continuous, and that it enables learning, and it enables shifts in mentality that are really critical to addressing and moving towards the change that we're driving.
Thank you. And I'm not seeing any questions in the chat or raised hands, but again, if folks have anything for our panelists, do feel free to let us know. Amy, do you have any thoughts on kind of long-term plans for NWEC and how you navigate your high-level goals with sort of the immediacy of proceedings?
That makes us sound very organized, Kate, so I appreciate that. And it's true, though, the NWEC does have a very long history of working in dockets at the commission, and we continue to advance on many of the same issues across proceedings and bring up similar comments. I sometimes find myself going back to comments we filed 10 years ago and remarking how similar they sound to what I'm saying now. Policies of the state and priorities do evolve, but I think the core of our mission has stayed consistent, and we do see a lot of value at working at the UTC because often that's where the real work to advance on our goals is happening for the state. So I think that I'll leave it there, but I think that the commission, I think, is a very important place to work, and it is often very wonky, and we're always happy to help new interveners just sort of navigate this space, because I think it is somewhat complicated to explore.
Thank you. And Tyler, you had kind of mentioned how you all navigate a little bit before. I don't know if you have anything else you want to add there. If not, I have another question, but I definitely want to give you some opportunity for this one as well.
Yeah, I mean, not too much to add. I think it's definitely true that the UTC is kind of like an ocean liner. It turns very slowly, and that's not a criticism of the UTC. I think that, frankly, it's just the utility system turns slowly by its nature, and so there's definitely times where we would like to see some sort of grand big policy shift, but we know that if we ask for it all up front, that it's not going to happen. And so breaking it into sort of bite-sized pieces over time can sometimes achieve a better result over a shorter period than if you just try to go in all at once, because you're likely to just get rejected if you try to do that. So yeah, that's kind of what I would say to that.
Thank you. And I want to be mindful of time. We're almost out. So I still don't see any questions, and we've got a couple more slides to get through. But as kind of a sign off, I was wondering if each of you in like one sentence could tell me something that you wish you had known prior to starting to advocate before the UTC. What's a lesson you had wished you had known, or a tip that you wish you had known? And we'll start with Marielle.
I wish I had come forth with, and it's something I already knew, but I wish I'd more firmly and confidently believed in from early on, is the power of plain language and bringing your authentic self to the space, and not feeling like you have to twist yourself inside out and upside down. And yeah, proceeding with confidence, even if it's sort of new and weird.
Thank you. Amy, any thoughts?
There's so much I didn't know when I started working at UTC because I didn't have any much background in the utility system, but just knowing that there are resources like this available, which is great that it didn't really exist when I started. There are also other resources that through the Regulatory Assistance Project that I think are really great reference materials for somebody who's coming newer into this space that helps define some of the terms that people kind of throw around. So I definitely encourage people to make use of those.
Tyler, do you have a tip or trick that you'd recommend to folks or a lesson you wish you had known early on?
Well, I would say, I mean, don't be afraid to reach out to people at the UTC. They're perfectly accessible. They're willing to work with you and to help on things and to answer questions. So, that would be one thing. Also, if you're going to intervene in adjudicative proceedings, which I think are important proceedings, read the procedural rules, because the UTC takes them seriously, but they're not all that hard to follow, but you just need to make sure that you understand what they are. So
great. Well, thank you all for your time, and thanks everyone for staying on. I know we're a little bit over, but Kristen, I think we can jump back to the presentation for the wrap-ups. I'm still not seeing any questions, but if there's folks in our audience that still have some about today or anything like that, we can go to the next slide. Please let us know.
Okay, thank you. Thank you to our panel. That was great. So we are at our time. I think we'll kind of swap these two slides because we just basically had questions and thank yous. So I will just say a thank you from the commission to all of you who have participated today. Let us know if you have any questions. We do have a survey that we would love for you to fill out. It helps us know if we hit the mark, if we were, if you found value in this, and it'll help us get better for the next time. So with that, if you're willing to stay and have questions for our panel, you can go ahead and we will do our question and answer session now, as long as people have questions. So thank you. And go ahead and raise your hand if you have a question, and we will go ahead and call on you. Any questions? I'm not seeing any so far. Wait for my dogs. I'll wait for another couple awkward moments. And if we don't have questions, then I think that we can be done. And thank you again for attending both of our workshops.
Thank you.